Okay, hello everybody, hello. There's so much going on. Oh my goodness. My voice is definitely on the mend, although I'm still kind of grumbly, but that's all right. Less coughing, so that's good. Hello, hi Jelly Kelly. Hello, Skynosaurus Rex. Oh my gosh, what a fabulous name. I love it. Hello. Sorry, everybody. I have lots of cocoa and throat drops. Yes, I was sick. And I have my immune system isn't great. So, regular illnesses where other people are like, man, this sucks, then it's over. Yeah, it lasts a little extra time for me. So, great. Actually, that's not great, but you do what you can with what you've got. So, here we go. Okay, here we are. Hello. Yeah. Long COVID. Oh my gosh. I'm so thankful that I don't have that. I'm so incredibly thankful. My heart goes out to those that are suffering and will continue to suffer, because that's, from what I've seen, absolutely awful, without much to ease that nightmare. So my heart goes out to them. Luckily, not me, though. Reaction video. I tell you what, Kristen, I was thinking about you. I was like, I haven't done a reaction video in a while. I'll just, I'll make one here, give a little shout out to Kristen. Howdy howds. But yes, oh yes, Toodle, the states are a-suing. They are not. Yes, I was thinking about doing another one later today, Kristen. So anytime you see one of those, I'm thinking of you, all right? But yes, we've got a whole bunch of states that are pretty upset about the SNAP situation. Hello, Invisible String. Happy Wednesday. Oh, hello, Kaya. I see that you're in there. Hello. So today's already been crazy. All right, we've had some craziness going on. Let me do a quick intro here before I dive into the lawsuit. So there's a lot going on. Oh, I'm so glad you got the notification, Beth Roney. Well, of course, Kristen, of course. Hello, Lisa. Welcome. Oh my gosh, illusion of choice. Listen, last night, I try so hard to keep my temper, especially because I know I have a bad one. But unfortunately, I had multiple triggers come at me all at the same time. That's not an excuse. I'm just telling you. It was awesome. Oh, I don't know about that. I'm not so sure about that, but I do try to be respectful because, of course, Amanda is a dear friend, and I don't want to be disrespectful to her or her live. But sometimes I can't keep the Hulk in. So, yes. Well, oh, thanks, Kaya. Oh, you're so sweet. Hello, Willie B. Oh, that's so sweet of you. That's so sweet. Yeah. Well, as I continue to get better, everybody, I'm not sure that I'll be able to go and join Manda every night, but she's been so sweet. So I can kind of get a little bit of my going live vibe going, but not hopefully too much. So every once in a while, absolutely. Oh my gosh, they were infuriating. Yes. Sorry, everybody. All right. Yay, Kelsey. Oh, thanks. Yeah. Oh my gosh, these nails, I'm telling you, they're my favorites. The whole Wicked line, everybody, and now this isn't sponsored, but the whole Wicked line, I am just absolutely loving from Kiss. Now, they just have released the Harry Potter line, And I was like, what? That looks amazing. But I'm going to have to think about that one. I mean, it's okay, but it's not particularly, extra. So I'm not sure. We'll see. You're here, Solid Chica. We love that. I'm so glad to hear that. All right, so let's dive in. I've only got about an hour here today at this time. I'm hoping to be able to come back on tonight. I couldn't yesterday. I knew my voice was shot, but I may be okay tonight. So quick roundup here for the roll call. Yikes. We have a lawsuit that has been filed by the states. I'll hit that one last, but we've had a couple of things moving forward on our two National Guard cases. So, of course, this is one, Newsom versus Mr. Orange. This is the appellate number, all right? So your district court number, right, is right here, right? DC number here. And then for the Northern District, and then up here is our appellate number. So once it moves into the appellate court, you've got to chase this number down if you're looking for it online. So we're out of the Ninth Circuit Court of Appeals. Now, the last we heard, we had a three-judge panel, and they said it looks like it's likely that withholding the guard is from Mr. Orange is wrong. So they had predicted, right? Because we don't have definitive decisions here, but they had put out it's likely that he would win on appeal. Now, that was our three-judge panel. And then here we had, we've got this motion for injunctive relief here that was denied. But then they came back and they said it was very fast, Ulysses. Very, very fast. And I think it's because the courts are watching them. And the courts are having to move fast with them, which they've never done before. So, but in this particular situation, they're like, you know what, we need more. So we need more here. So that's what's going to happen. We need more judges. So let me just make sure I put that out correctly, because I've got the California case, but then I have the Oregon case. Let me make sure I wasn't telling you about the Oregon case. Hold on a minute. This case should be here. My apologies. It was Oregon. It was not California. All right, we got three cases. We have California, right? And then we have Oregon. And then, oh yeah, Oregon's the one. Sorry about that. And then we also have Chicago. And they just had a hearing, so we don't have an order there. All right? So we'll try to keep these straight. Well, let's go back here to California for a second, because this was an order that came today. Motion for injunctive relief because district concluded it lacks jurisdiction for renewed injunctive relief. It's true, pending interlocutory appeal divests the district court of its control over those aspects. And this is what's rough, because this Coinbase case was just decided a couple of years ago. An appeal from interlocutory does not stay the proceedings. As it's firmly established, an appeal from interlocutory does not divest the trial court. So they're trying to get everything paused, it looks like, while they go through the appellate process, and the court's saying no. This motion for injunctive relief that you're requesting is not necessary. So that's quick. That's a super quick overview of California, which I had processed in my mind as Oregon. But now back into Oregon. Here we go. We've got October 28th filing. So this is probably what's hitting the news everywhere. Probably. We did, again, this was the case where we had the court saying in the 94-page decision, the court came out and said, well, we think that this is going to be okay. It was legal for Mr. Orange. And so you need to let the troops, let the federalization and the employment deployment go forward. All right. So this was the lawsuit order from district court. Now that got appealed, and the appellate court here Let's make sure we get 2 dates. We have October 20th here. This is the en banc coordinator. So a judge of this court, sua sponte, requested a vote on whether this case should be reheard en banc pursuant to law. The parties are requested to file simultaneous supplemental briefs addressing whether this case should be reheard en banc. The brief shall be filed on or before midnight, October 22nd, not over 14,000 words. So when we've got a 3-judge panel, they can make their decision, but then you can ask for en banc review, which means the entire bench. All right, now originally, I think we had been hearing we're not going to do en banc, but then here we are, and we're doing it now. We're en banking everyone in Portland. So, upon the vote of the majority non-recused active judges, it's ordered that this case be reheard en banc. So, at first it was denied, but now it is approved. So, we'll be waiting for that new docket to come out. All right, is everybody caught up despite my confusion? Most important thing to remember, California is not Oregon. Let's remember that. Yes, so en banc. En banc, right. Is what I'm saying here. And it's up to our Court of Appeals. Our Court of Appeals really have a lot of wiggle room on what kind of cases they want to hear and how they want to hear the cases. At least that's what it's been, forever. So here, again, if you lose that 3-panel judge, then people assess the case and they figure, well, let's take it to the next step of en banc, or let's skip en banc. All right. Waving from Oregon. Oh my gosh, upgrade. You got to keep us posted. This is like landmark case here. We are making history with these. And many may say, I don't want to make history. And to that I say, I agree. But alas, it is what we have here. All right. So California's working its way. Oregon, just today was granted this en banc jurisdiction. All right. So we'll keep our eye on that. Again, my voice, everyone, is still not quite right yet, but excuse me, we'll get there. And then as a side note, absolutely not related to anything regarding the administration. Excuse me. Hello, Tiffany. Hello. We do have some kind of new stuff that's being kicked around a little bit in the Mangione case, right? Everyone remember this one? I'm not tracking this one particularly closely unless I see something very interesting, which I did. So I printed out. This is the whole docket. All right, so we've got orders put into the docket here, which I don't know why they can't. See, down here it says a main document. So they put all of this into the docket and then come back with an order. It's very messy. But alas, that's not something I can control. All right, so it looks like what I wanted to bring up is that we do have a motion to dismiss on the floor here. Let me see if I can find it here. We've got amicus briefs that have been filed. We have some very interesting pieces about that. Let me see here. Excess pages, endorsement, motion for leave right, here it is, it's right here. A motion to dismiss counts 3 and 4 and to suppress evidence and statements. This is really important. This is one of the biggest tools that criminal defense attorneys have, is this particular one right here, because you're saying that any information that came out illegally needs to be suppressed, and that means it needs to be kicked out of trial. So they are filing and they are saying, look, we've got some stuff here that we think should be kicked out. Here's some exhibits and such. And so we want to hear about it. Now, we don't have an order. This is something that would need to go to a hearing. Here we've got a reply. We've got a brief granted, another letter filed by the U.S., as to, right, letter by the U.S. again, consolidated brief. So that's mostly just housekeeping paperwork questions. And then over here, we do have a reply and a sealed document. So we don't know what this is, but I think we should hear relatively soon if we're going to have a motion to dismiss slash suppression hearing. And when it comes to a piece of evidence that needs to be suppressed, there needs to be a hearing usually. There doesn't always have to be, but it would be best, especially with this caliber of a case. All right, so we're all caught up. We're all caught up. Why is the DOJ getting caught using false information? And why is the bar not doing more? Excellent questions. The Department of Justice, I've said this multiple times, because of the attorneys in charge and because of the Attorney General, they have lost credibility and the ability of our judges to actually believe them. Because that's a lot of your legal work, is that you have to make sure your reputation doesn't get destroyed. It's a little bit like, dating back in the 1600s. No, it's nothing like that. But what I'm trying to say is that if your reputation gets damaged by bad acts, the courts are going to know that. So what we're having happen here we're having U.S. attorneys, at least in California, a little bit in New Jersey, dinking around, not doing things right. And then out of the Department of Justice as well, where we've got DOJ attorneys doing things that our courts are saying, no, you have done the wrong thing here, which of course we did already have a finding of probable cause for contempt in the DC case that was ultimately moved around and tossed. But yeah, so those attorneys, who's going after them? And the bar, wherever they're registered, wherever they're licensed, is in charge of the ethics. So there have been multiple complaints filed, and I think the American Bar Association itself has filed something in Florida to try to sanction Bondi. So we are moving. It's just very slow. Oh, yes. Thanks for the gifts, everybody. Hello, Erin. Hello. Welcome. Yes. Thank you, Erin. Yes. Hi, Willie B. Yeah. We're pre-approved. Go Life is pre-approved. I tell you, the trolls have been so terrible lately. My moderators and my friends here are so amazing to help block some of that out. And I appreciate that. All right, here we go. The last thing that I want to dive into was just filed, just like a couple, maybe last night. And this is Commonwealth of Massachusetts versus the Department of Agriculture. This is the SNAP's benefit, right? So we've heard SNAP is going to be, because of the government shutdown, those benefits aren't going to be out there. Oh my gosh, did I miss it? No. Oh no. Well, the great thing is that once I download this, then I can watch it again. So thank you for that, everyone. And I do. I really just fast forward to watch all the fun things that I miss in the chat. All right. So here we go. Back in it. We've got a complaint against the government for the SNAP benefits. So again, this was just filed yesterday, but look at the docket already. We can see the complaint was filed, which I'll walk you through the beginning of that. And then we have motion for temporary restraining order here as well. And we've got support for that. Electronic notice, summons is being issued to the government, declaration in support of the restraining orders. And then we have exhibits. I mean, we've got 41 exhibits. That's a lot of exhibits to just set out right out of the gate. So this is a huge case. This is enormous. Now, whether jurisdiction will continue to go, don't know. Whether this will come to any fruition in a time period that would actually be incredibly helpful for people, don't know that either. So we'll have to just kind of wait on that. So here's the complaint, everyone. Let me get a little sticky note here. That's a good question, Kristen. Good question. And Gavin's all over this. I mean, I would say out of all three, he is just like, they were the first, and so he's not playing around. And I absolutely love that. I need people to stop playing around. Like the knee pads, did everybody see that those sold out? That's one of my favorite things that's happened so far. Oh my goodness. All right, so let me make my sticky note and we'll dive here into just kind of the introductory piece. So we're gonna, oh my gosh, we're gonna call this, we'll call this Massachusetts because that's how the docket's listed, but we're gonna say Massachusetts, Massachusetts, and then we'll do et al. I think there's 20 in here, 20 different states, versus Department of Agriculture here. Okay, Department of Ag. And there, and this is the SNAP lawsuit. And, you know, I believe too, WIC is involved in that as well. So I'm just kind of using SNAP as an overall term. Technically not quite right, but anyway, so we've got a lawsuit. It was filed 10/28. So here we go, everybody. Oh, no, about the knee pads. I think they sold out. Everybody. But I know. Your life's ours. Oh, thanks so much, Blue Age. I appreciate that, especially right now in the era of the trolls. Here we go, diving in. Here's our states up here. Let's go through them. We've got Massachusetts, California, Arizona. Let's highlight these, shall we? All right, Massachusetts, California, Arizona, Minnesota, Connecticut, Colorado, Delaware, District of Columbia, Hawaii, Illinois, and then we have official capacity people. So this person here, so Kansas as the governor of Kansas as opposed to Kansas, the state. Office of the governor here, so Andy. For Kentucky. Oh, look at that. We've got 2 governors where the AGs are like, we're not going to do anything, but they're still coming in. We love that. All right. Maine, Maryland, Michigan, Nevada, New Jersey. Geez, I don't know if I've ever seen this many states on one petition before. State, New Mexico, New York, North Carolina, Oregon, of course. Oregon's like our champion right now. California and Oregon and Washington, quite frankly, y'all doing good work out there. And then Josh Shapiro, who is the governor of Rhode Island, right? Sorry, Pennsylvania, my bad. I know not all of the East Coast states are the same. And then we've got Rhode Island in its own spot, Vermont, Washington, and Wisconsin. That's a lot, everybody. Yes, Pennsylvania, thank you so much. I can't imagine how how offensive it must be to be accidentally mistaken for Rhode Island's governor instead of Pennsylvania. So I apologize. There's always been kind of a West Side Story situation going on with Pennsylvania and Rhode Island. Anyway, I digress. We've got a lot of states here, and they're going against the Department of Agriculture here. And the Secretary of Agriculture, Office of Management and Budget, Russell Vogt, he's been sued a heck of a lot here, Director of the U.S. Office of Management and Budget here, and the United States of America. So, you know, just the country. That's who they're suing. All right, so let's dive in here and see what's going on. No, Ohio. Unfortunately, but this is still a lot. This is still a lot of states. Let's just count them out real quick. 1, 2, 3, 4, 5, 6, 7, 8. Well, I mean, Hawaii. We're going to count District of Columbia. 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24. Literally half of the United States is on this petition. So we're going to put approximately 24 up here. That's a lot. I would take this moment to remind everybody, last night on the live, there was someone who was very concerned about whether or not Mr. Orange could run for a third term, right? Very concerned about that because the rules aren't being followed, the laws aren't being enforced, blah, blah, blah. And to that, I answer, first of all, everyone is worried and has a lot of stress. Number two, you must remember when it comes to elections that elections are run by the states. The states have sovereignty. We have 24 states coming in here, literally saying to the federal government, you guys are out of line. So when it comes to that question on elections or running again, even though it may be a violation of the Constitution, just, you've got to put some faith in the states. And that, I think, may help you feel better, if anything can. Right. Exactly. Right, I got it. The voting machines. Yes, I've got it. But also, when it comes to making sure that our elections are free and fair, we already have an infrastructure in place. We've had it in place for a long time. And the only thing that is in question is the rhetoric that Mr. Orange is putting out there about how machines are going to get compromised or ballots are going to get compromised. It's like, again, go grassroots and see how seriously they take the election and how serious they are about voting. So, last time we had the election, a lot of the secretaries of states and various other people are coming out and saying, we have all of these huge protections in place. Those protections aren't going to be removed. They will only be added to. So I am not worried about the actual election itself as it comes. Right. Kelsey, right. Right, exactly right. Is it Al Fiore? Yeah, that's exactly it. You have to go through the state in order to get your name even on the ballot to run, right? So that's kind of the thing. How would anyone know if the machines get compromised? Well, there's already people in place that check that. There's already different pieces. Now, something else to think of as well is some people are saying, and again, I don't follow all of this, but that somehow the machines, like Mr. Orange owns the machines or whatever. And, the states then would have to determine whether or not they're comfortable with that. So maybe they want to go with a different machine company. Who knows? They don't all use the same supplier and the same machines, but it's up to the states to be like, I trust that this will be okay. A billionaire bought Dominion, right? Well, and the presidency. Goodness. The swing states involved in filing these lawsuits. Oh yeah. We've had tons of states, tons of our swing states. Now, I'm not sure you would really put Nevada, New Mexico, Arizona as swing states, but I kind of see them as purple. So we do have that. And let's see, Illinois is not really a swing state, but Wisconsin's in here. We don't have Michigan. We don't have a couple of the others, like there's no Iowa in here, but they have filed in other lawsuits. For sure. Yeah. They changed the code when they removed, probably. Oh, thanks, Thomas. The other thing too, though, everyone, is for those of you in the comments who are so worried about the machines being compromised, you all make me feel better, because by saying that, I know you're going to have just really careful watch of what they're doing. So you actually are working to keep that in check, and I'm grateful for that as well. All right, diving in, introduction. For decades, low-income Americans have relied on the Supplemental Nutrition Assistance Program, also known as SNAP, to put food on the table, formerly known as food stamps. Across various previous federal government shutdowns, SNAP benefits have never been interrupted by a lapse in appropriations, meaning money, right? Until now, earlier this month, a defendant, U.S. Department of Agriculture, suspended SNAP benefits for November. Because of the USDA's actions, SNAP benefits will be delayed for the first time since the program's inception. Yikes. Worse still, USDA suspended SNAP benefits, even though on information and belief it has funds available to it that are sufficient to fund all or at least a substantial portion of November SNAP benefits. Suspending SNAP benefits in these circumstances is both contrary to law and arbitrary and capricious under the Administrative Procedure Act, which of course we use these magic words, arbitrary and capricious, as a foundation for violations of the APA. All right. USDA's suspension of SNAP benefits is irreparably harming plaintiff states, a harm that increases every day SNAP benefits are delayed. Plaintiff states are therefore forced to seek this court's intervention to forestall further irreparable harm from the USDA's illegal action. So again, this is just 24 states suing the federal government for not doing its job, right? I mean, this is just, huge. This is a huge thing. Jurisdiction and venue. The court has jurisdiction pursuant to 28 U.S. Code Section 1331, 1346, and 2201A. Venue is proper in this district pursuant to code. Defendants are United States agencies or officers sued in their official capacities. The Commonwealth of Massachusetts is a resident of this judicial district, and a substantial part of the events or omissions giving rise to this complaint occurred within the District of Massachusetts, right? So we're definitely making sure we're filing in a place where someone has been harmed. So be careful of that. All right. Next up, the plaintiffs. I'm going to probably skim through this pretty quick since we kind of already talked about that. And hot chocolate. I'm all teed out, everybody. I've had so much tea. I'm like, meh. All right, plaintiffs, Commonwealth of Massachusetts. We've kind of already gone through this. California here, Arizona, Minnesota, Colorado, Connecticut, Delaware, DC, Hawaii, Illinois, governor of Kansas. Is Kansas a swing state, everybody? Or is it, I don't know that Kansas is a swinger. I think they're just red, right? Both Kansas and Nebraska and South Dakota, I think are just red. They're not swingers. Okay. Thank you. Okay. It's red. It's red. Ooh. All right. Red. They don't swing. All right. They can swing. Can't. Really? All right. Oh, Democratic governor. Right. And she's the one that's hopped in on this lawsuit. Good for you, Madam Governor. Here we go. We also have Kentucky governor here. Maine, Maryland. Of course, Maryland would be in there. Michigan. Oh, Michigan is in here. That's a swinger, right? I wasn't sure about that. Nevada, New Jersey, New Mexico, New York, North Carolina, Oregon, Josh Shapiro, Pennsylvania, which I will never forget now. Pennsylvania, and then Rhode Island, Vermont, Washington, Wisconsin. Here. Yes, we are. Oh, I love it. All right, and then we have the defendants, and the defendants are USDA, of course, Secretary of Agriculture, Management and Budget. The OMB is getting sued left, right, and center. I think they may be the one agency getting the absolute most. All right, so Russell Voigt, and then the entire United States of America. So, ouch. For exercise of executive actions by named defendants. So if you're seeing the United States of America being sued, automatically just switch over in your mind. It's the DOJ. All right, so you can kind of keep that. Oh, yeah. That's the other thing, too, VC. Absolutely. If you're worried about the elections, then, go on, get in there, get trained, go in and watch and stuff. Hello, June Marie. Is Nevada swing? I was wondering, too, with Arizona, Nevada, New Mexico. New Mexico and Arizona were the ones that were kind of in that fake elector scheme. So I'm not really sure. Here we go, background number 1. Plaintiff states serve millions of food insecure residents through SNAP. First authorized in 1964 as the Food Stamp Program, the Supplemental Nutrition Assistance Program has long been the country's primary weapon against hunger and an essential safety net for low-income Americans. The goal of SNAP is to alleviate hunger and malnourishment by increasing the food purchasing power of low-income households. Citing case law here, it is declared to be the policy of Congress in order to promote the general welfare, to safeguard the health and well-being of the nation's population, which is set out as a requirement in the U.S. Constitution, by raising levels of nutrition among low-income households. To achieve this end, SNAP provides monthly benefits to eligible households that can be used to buy food. FYI, the food you can buy isn't just anything that you want, by the way. There are some limitations on that. Not many, but there are some. Through SNAP, eligible recipients whose net income cannot exceed the federal poverty line, or around $31,000 per year for a family of 4 in 2025, receive electronic benefit transfer cards that are loaded with benefits each month that recipients can use to purchase food at participating retailers. Again, it doesn't work everywhere. You can only use it in certain places for certain things, right? So keep that in mind. The process of applying for SNAP benefits isn't just, show up and we give you stuff. You have to go through the process. You have to fill out the paperwork. You have to constantly keep everything updated. So it's not just like walk around, oh, great, here's some money and I can do whatever I want. That's not how the program works. In 2024, SNAP helped more than 41 million people avoid hunger or malnutrition. Down here at the bottom are the footnotes explaining where the citation is, right? So where they're getting these numbers. So more than 62% of SNAP participants are in families with children, or more than 37% are in families with members who are elderly or have disabilities. Collectively, in a month, plaintiff states provide nearly 25 million individuals and nearly 14 million households with food assistance through SNAP. Nationwide, for the federal fiscal year 2024, SNAP benefits averaged about $8.3 billion per month. All right, so there's that. Yeah, this is just awful, right? I mean, I've been thinking about, the school lunches. They're not giving any free school lunches. So just to make sure that we're following this, in those states where the free lunches are no longer an option, so the kids don't get lunch, now the SNAP is gone. So now they don't get breakfast or dinner. So, because sometimes that lunch is the only nutritious meal of the day, and that's gone. So literally no food for children in the United States. It's very upsetting. Here's how SNAP operates at the federal level. SNAP is overseen by FNS, a component of the USDA. It is state agencies, however, that are responsible for the administration of the SNAP programs. States are responsible for creating and processing applications for benefits, making eligibility determinations, issuing benefits, and ensuring program integrity. So that, again, is that Argentina, I know, right? The administrative costs of operating SNAP are paid by both the state and federal governments. Currently, the Secretary is authorized to pay each state agency through fiscal year 2026. 50% of all administrative costs involved in each state agency's operation of a SNAP. Now, the plaintiff states each administer their own SNAP program. For example, in the Commonwealth of Massachusetts, the SNAP program is administered by the Massachusetts Department of Transitional Assistance, which has a statutory mission to assist and empower low-income individuals and families to meet their basic needs, improve their quality of life, and achieve long-term economic self-sufficiency. SNAP, Massachusetts' largest anti-hunger program, is a key part of the Commonwealth's efforts to address hunger by supplementing the food budget of low-income families so they can purchase healthy food. Thus far, in 2025, an average of 1.1 million people receive SNAP benefits in Massachusetts each month, including approximately 665,000 families, 342,000 children, and 261,500 elderly individuals. Households in Massachusetts receive on average $323 per month in SNAP benefits to meet their basic subsistence and nutritional needs. So this is what they're getting. Again, I just have to say here, there is this unfortunate kind of generalization that people who are low income are lazy or are just doing it to get benefits. And, you know, there's good and there's bad people in the world, right? There are low income people that are not good people, just like there are low income people that are amazing people, right? People are people. So you can't just give certain qualities to an entire group when you're dealing with people. And that absolutely drives me crazy. All right, soapbox, putting my soapbox away. California's SNAP program is called CalFresh. Of course it is, it's California, right? CalFresh is overseen by California Department of Social Services, but the certification of applicant households and the issuance of EBT cards is managed by California's 58 counties as authorized by federal law. Here and here. CalFresh is the second largest social services program in California after Medi-Cal, California's Medicaid program, and it provides an essential hunger safety net to an average of 5.5 million Californians per month. Since the beginning of the federal fiscal year of 2025, approximately $1.07 billion in CalFresh benefits have been issued each month. Annually, California and the federal government each covers over $1 billion in administrative costs. Each month, approximately 1.9 million SNAP recipients in California are children. They're children. Oh my gosh. All right, let's go to Arizona. In the state of Arizona, the SNAP program is administered by the Arizona Department of Economic Security, which carries out its mission through work with individuals, families, community, and advocacy organizations, and state and federal partners to facilitate the safety and economic security of persons who qualify for benefits and services in the state. So yet again, you've got to qualify. They don't just hand them out for fun. In federal fiscal year 2024, an average of 950,978 people receive SNAP benefits in Arizona each month, including 401,455 children and 135,677 elderly individuals. More than 2,029,794. Did I get that wrong? That's a billion. Is that a billion, everybody? So this is a million, this is a billion, this is 1,000, this is 100. 2 billion. All right, we're going to round it up. I am back, yep. My voice isn't quite back, but I'm back. So spend a lot of money, everybody. 2 billion. Let's just clarify that. In Minnesota, The SNAP programs administered by the Department of Children, Youth, and Families, which administers programs to keep children safe and provide families with supports to care for their children. In federal fiscal year 2024, an average of 440,000 people receive SNAP benefits in Minnesota each month, including 181,980 children and 67,000 elderly individuals. No, it's a fight. You've got to fight in order to get it. On top of how you already feel, and sharing my story. Of course, when I was just a young wee lass, I could not bring myself to go in and actually apply for food stamps because I was so humiliated. I was so full of shame that I couldn't make enough money at my 2 full-time jobs while I was going to night school and paying for my own apartment and not paying health insurance. I could not bring my pride under control enough to go and apply. So I wish that I had, if I could go back in time, rather than having to pull food out of the garbage. So, you make those choices, and sometimes so many more people need the help but are unwilling to take it because they're ashamed of their situation. I think that's part of society. Exactly right. Exactly right. All right, state of Colorado. Its 64 counties determine SNAP eligibility and authorized benefits, while the state oversees the SNAP program. Under Colorado law, Colorado Department of Human Services, Office of Economic Security fulfills the state of Colorado's responsibility. Consistent with federal law, CDHS is responsible for issuance, control, and accountability of SNAP benefits and EBT cards, ensuring program integrity and supervising counties' day-to-day administration of SNAP, including processing applications for SNAP benefits and certifying eligible applicant households. So they have enforcers in Colorado. They're very clear about that. We have people watching to make sure that everyone's following the rules and not trying to, game the system. SNAP is a key part of Colorado's efforts to address hunger by supplementing the food budget on low-income families so they can purchase healthy food. In 2025, an average of 612,931 people received SNAP benefits in Colorado each month, including over 306,000 children and about 114,000 elderly individuals. More than $1.4 billion, thanks for writing it that way, in SNAP benefits were issued during 2024 in Colorado. Yes, Minnesota's very strict. Right. Farmers markets do take SNAP. They do, and we love that, right? Because that helps you, get even better quality items. Healthy communities benefit us all. That's right. Because I tell you, when you're hungry, eventually you can push that hunger to the side. How do we know that? Well, has anyone seen the models out there? You just push it to the side. But eventually it will have an incredibly negative effect on your brain, right? So when your brain's being affected, then it's hard for you to make good choices. In the state of Connecticut, SNAP is administered by the Department of Social Services. SNAP is a key part of Connecticut's efforts to address hunger by supplementing the food budgets on low-income families so they can purchase healthy food. Thus far in 2025, an average of approximately 366,000 people receive SNAP benefits in Connecticut each month, including approximately 215,000 families and 120,000 children. Households in Connecticut receive an average of $324 per month in SNAP benefits to meet their basic subsistence and nutritional needs. During the federal fiscal year between October 1st of 2024 and September 30th of 2025, DSS issued approximately $72 million, right? That's million. $72 million per month in SNAP benefits in Connecticut. Right. Yeah, we're definitely, we're in the in the bad place zone. This could really take a terrible turn. In the District of Columbia, here will be our last place, just to give you an idea again of how these programs work. In the District of Columbia, SNAP is administered by the District of Columbia Department of Human Services in fiscal year 2025. An average of 141,000 people receive SNAP benefits in the district each month, including 47,000 children and 24,000 elderly individuals. More than $320 million in SNAP benefits were issued in fiscal year 25. That's a lot, everybody. All right, so I will kind of fast forward us here. We've got Illinois, we have Kansas, we have Kentucky. Again, these both of these are their governors that have stepped in to be part of the lawsuit. Here's Maine, Maryland, Michigan, New Jersey, and so forth. So everybody is included, and they set out how everybody's SNAP program works, which I think a lot of people just don't understand. Ray, yes. So this is the complaint filed by the states against the Department of Agriculture. All right, SNAP benefits are appropriated entitlements. This language is very important, right? If it's appropriated, it means Congress decides under the Constitution. So we got to make sure that that's straight. Not anyone else. It's Congress. So Congress has provided that assistance under this program shall be furnished to all eligible households who make application for such participation. Additionally, Congress requires that participating states implement plans of operations requiring states to promptly determine eligibility of each applicant so as to complete certification of and provide an allotment retroactively to the period of application to any eligible household, not later than 30 days after applying. And where an applicant is especially impoverished, the state plan of operation must provide that the state agency shall provide benefits no later than 7 days after applying. So let me stop here for a minute to just send a shout out here, because although states run these programs, they also have to work with the feds, right? Now, more now than ever before has it been hit home that you have to follow what the feds want you to follow, or you will lose your federal funding. SNAP is the same. You know, if the feds are coming in and they're saying, you know, we want these restrictions put on in place, and if the state's like, okay, that's fine, then they'll come in and do that. So although run by the states, of course, there has to be federal compliance. Yeah, exactly. Emergencies. All right, so Congress has declared it to be a policy that SNAP would increase food purchasing power for all eligible households who apply for participation. Another point too, with all of these prices going up, right, with the groceries being ridiculous, and families are getting, you know, not that much. What is it? You can get like $350 a month. Like $350 a month. Think about that. If you just buy like, I don't know, let me think here. It'd be maybe 10 packs of Oreos. Boom, budget's gone. No more money. All right. So for those people out there too saying, well, you shouldn't be buying junk food and stuff, which who cares? I mean, if you are in a situation where you need SNAP, you're busting it to try to get out of that. And so it doesn't matter. If a thing of Oreo cookies can make you feel better, get you ready for that job interview, you go for it, you know. There's just a lot of judgment though. So keep that in mind with how expensive things are. I think I saw a TikTok yesterday where someone had bought a package of meat. It was like $25 for like this one little package. Like, what are we talking about? Mandated to provide. Right. I feel as though billionaires are going to make us start paying for air. It does seem that way, doesn't it? It certainly does. And again, as a friendly reminder, like we are the ones that made them billionaires, right? That money isn't like just being issued out of, Fort Knox. No, the money that they're counting literally comes from us. So you got to kind of keep that in mind when we're out there. Further, Congress has provided that SNAP benefits are obligations of the United States within the meaning of Section 8, Title 18. Congress has also elsewhere treated SNAP as a form of direct spending, distinct from discretionary appropriations, the latter of which are budgetary resources except to fund direct spending programs provided in appropriation acts. In sum, it is well understood that, as the Government Accountability Office explained earlier this year, oh dear, SNAP is considered an appropriated entitlement, meaning that the government is legally required to make payments to those who meet the program requirements, and that USDA's liability extends to the availability of appropriations for these payments. All right, and I'll go ahead and stop here for our little short, quick and dirty live today. But there you have it. I would like to come back, and I will be coming back to go through more of this as time goes on. But we literally just had this filed in the wee hours of the morning, so even our docket is pretty lean at this point. But I think it'd be interesting, though. You can go again to where I go, which is the best thing ever, and I'm so grateful, is for the court listener, right? So even though this goes through Pacer, Court Listener has it set up online so people can go in and find it for free. And you can come in here and you can look and see what exhibits they're talking about, because each one of these exhibits then is also going to be available, right? So we've got a motion for a restraining order. You're like, well, why are they doing that? Well, take a look at the exhibits, see what you think. So with that, my friends, I do need to sign off for now. I am really hoping I can come back tonight. It would be later in the evening, I believe. But hopefully soon I'll be able to do that. But thank you all again for coming by. Always fun to share information, and especially when we've got so many misunderstandings here going on. So take care. I'll see you all again very soon. And Erin, thanks for coming and hanging out with us today. I appreciate you so much. Thank you also, moderators. Take care.